Okay, welcome back to intellectual property. In today's class, we're going to continue our conversation about trademark law by beginning to look at how courts go about determining whether or not a plaintiff has made a viable infringement claim against an accused product. In other words, what does a plaintiff have to show in order to prove a likelihood of confusion between their product and the accused product in relation to a particular distinctive mark? And how should we think about that in relation to trademark policy? So, as we discussed in our last class, a trademark is just any distinctive mark that's used in commerce. And as I said before, distinctiveness is really doing a huge amount of the work here, right? Distinctiveness means that a particular mark is communicating information about the source of a product or source of a product or service to consumers, right? So why are marks protected? Because people are using them to sell things to consumers, and those marks are telling consumers who are making the product or service in question, right? So it's all about communicating information. That's the key to trademark protection, is communicating information about source to consumers. As we pointed out in our last class, right, you have to prove that a trademark is actually valid. So it's actually communicating source about information about source to consumers. You have to prove that you're the owner of the mark. And then finally, you have to prove that there's an actual consumer confusion or risk of consumer confusion based on the accused mark in order to make out a claim for trademark infringement. Okay, so we talked a little bit about the hierarchy of marks, sort of a framework that courts use in order to try to evaluate, or maybe more cynically, explain their evaluation of whether a particular mark is actually sufficiently distinctive to be protected by trademark law in the first place, and therefore the potential subject of a trademark infringement action. Let's think about how the infringement analysis actually works in practice. So what was going on here? We've got two different tobacco brands, right? Two big major tobacco brands selling loose tobacco, right? So this is tobacco that people would buy to use in order to roll cigarettes themselves. Okay, one brand is the famous Top brand, right? Their word mark consists of the word TOP in capital letters. You can see the little circle R there on the Top brand logo, indicating that the mark has been registered, and it's associated with a spinning top in red, white, and blue. Okay, so this is a well-known mark among tobacco smokers and available for sale under the brand name Top. Well, what's the problem? A competitor, Zig-Zag, which is arguably better known for cigarette papers rather than tobacco, but nonetheless in the loose tobacco business as well, begins selling its tobacco in a new kind of container. And they refer to the container that they've developed in order to sell their tobacco as a fresh top canister. Essentially, as I understand it, means like you open it with a key, so it's like vacuum sealed to maintain the freshness of the tobacco in the can. Well, Top is not happy about their competitor using the word top on their packaging. And it says, look, we've registered the word mark Top for use in relation to tobacco products. Zig-Zag is selling a tobacco product, and they're using the word Top to sell their tobacco. They're infringers, right? From their perspective, this should be really straightforward. We own a registered mark in the word Top for tobacco. They're using the word Top without permission, and you'll see that Zig-Zag has identified fresh-top with the term TM, right? Which means that they're claiming trademark protection, right? They're claiming that this is a distinctive name, presumably for the container, not for the source of the tobacco, right? But the TM means that they haven't registered it yet, right? Circle R means that the term has been registered with the USPTO. TM means that they're claiming trademark protection, but it hasn't yet been registered and may or may not have a registration filing, right? So the marks can tell you a little something about the status of the mark in question and what the putative mark owner has done to pursue registration and ownership of the mark in question. Okay, so TOP's argument is very straightforward. You're not allowed to use TOP in relation to tobacco products. You are, therefore you're infringing. Okay, the court isn't having it, right? Because the court looks at the products in question and says, look, no consumers are going to be confused about the source of the products in question, right? I mean, yes, it's true that Zigzag is using the word top in relation to the sale of loose tobacco, but it's using it in a way that no consumer would think that they're referring to the source of the tobacco rather than the nature of the canister in which they're selling it. Right? In other words, the court says, look, you have to look at the context. You have to look at how the mark is actually used. You can't just isolate the particular word mark and say, top has an absolute right to use the term top exclusively in relation to the sale of tobacco. You have to look at the word mark in the context of the entire product and how it's actually used in practice. And here, what's indicating source to consumers? Well, the big logo that's telling consumers who made the product in question, right? So is any consumer going to be confused about what, whether they're buying top tobacco or zigzag tobacco? No, because the zigzag tobacco canister says in big letters on it, zigzag, right? And the top is only used to identify the nature of the canister that they're selling the tobacco in and the qualities of the canister rather than the source of the tobacco. So the court is not having any of TOP's arguments here. It says, look, there's no risk of consumer confusion. Therefore, there's no basis for a trademark infringement action. Now, TOP tries to point out that, well, in some catalogs, they use the word fresh top without without having any additional context. The court isn't taking that seriously either, right? Because if consumers can tell the difference between the products, then the people who are buying products for stores are going to be able to tell the difference are going to be able to identify the source of the product at least as well, if not better. After all, they're in the business of selling tobacco and of buying tobacco and figuring out where it came from. And there's no realistic argument that this is going to be a problem. Okay. So what then are the benefits of registration? As I mentioned in our last class, registration is an option for trademark owners, but is not required, and is not required even for litigating a trademark infringement action, right? So a plaintiff, a trademark owner, can sue on an unregistered mark almost just as well as they can on a registered mark. However, there are certain benefits that come along with registration. Specifically, it provides evidence that's valuable for trademark owners in proving validity of the mark and ownership of the mark, right? In other words, if you've registered a mark, then the burden is going to be on the defendant to show that the mark isn't valid or that you aren't actually the proper owner of the mark in question, as well as providing notice to everyone in the country, at least, they're kind of on record as being notified of your intent to use the mark and its registration. There are certain additional legal protections, including, inclusion in the customs database, which helps trademark owners protect against infringement by foreign imports from foreign imports, as well as certain defenses against state law dilution claims. We'll talk about that. Later. And then finally, one thing that's very valuable, especially for people who've been using particular mark for quite some time, is the possibility of obtaining incontestable status for a mark. And so essentially what that is, after a fixed period of time, a trademark owner can apply with the trademark office to determine that their mark has become incontestable. And essentially what that does is reduce the number of defenses that are available to the user of an accused mark or an allegedly infringing mark on an accused product, right? So essentially it makes it easier for trademark owners to win a trademark infringement action because there are fewer defenses that their opponents can bring. Okay, so what happens in the registration process? If you want to see in more detail, you can go to the USPTO website, look up a trademark, and actually look at all the documentation. But in a nutshell, what happens is the putative trademark owner will file a registration application with the USPTO, which will then assign that application to an examiner who will look at the application and determine whether or not the mark that is being applied for is actually registrable. In other words, does it satisfy the criteria for registration? They may have a back and forth with the applicant to determine whether there might be a need for a disclaimer of certain elements of the mark or a narrowing of the mark from what's actually being claimed. And the examiner will either then agree to grant the mark or not, and it'll be published for anyone else to see. So if someone wants to file an opposition, they'll be able to do that as well. In other words, if a competitor says, hey, this person is trying to register a mark, but I'm using something really similar, I don't think they should be able to register the mark at all, or I think the mark that they're trying to register should be registered in a narrower form, then there's an opportunity for a back and forth with other people in the market. Finally, if the examiner ultimately refuses to register the mark, then there are various opportunities for appeal, both internal to the PTO, to the TTAB, or Trademark Trial and Appeal Board, also to appeal from there to the federal circuit, or in the alternative, to bring an original action in federal district court. Okay, once the publication has happened and there's been opposition, then the certificate of registration will issue, and ultimately, years later, the registrant will have the opportunity to apply for incontestable status. Now, statutorily, certain kinds of marks have historically been excluded from registration. Some on the ground that they presumably don't operate at marks in the first place, right? So if a mark is merely descriptive, that means it's not distinctive, therefore it shouldn't be registered. That's why they would be excluded. In addition, if a mark is deceitful, right, or deceptively misdescriptive, well, then it's conveying information, but it's conveying false information. And that's not the kind of thing that we want to see registered as a mark. It's deceiving consumers about the source of a product rather than providing them with useful information about the source of a product. Likewise, using somebody's name, image, or signature without their consent, right, would also be deceptive and improper, and therefore not the kind of thing we would want to register, even if it could indicate the source of the product in question. The big controversy in recent years, however, has been over the limitation on immoral, deceptive, scandalous, or disparaging marks, essentially requiring the USPTO to make value judgments about particular marks and whether or not they should be registrable. And admittedly, there was a certain amount of arbitrariness in the decision-making process, especially because different registration applications went to different examiners. In any case, came to a head a few years ago in the Supreme Court case Mattel v. Tam, in which the musician Simon Tam and his band The Slants filed a registration application for the name of their band, The Slants, which was a Asian American dance rock band. And the registration was denied on the ground that it was disparaging to Asian Americans. And of course, they were quite flummoxed. They didn't anticipate having any problems with registrations and came back to the USPTO saying, hey, we're Asian Americans and we're using this term because we want to reclaim it in order to prevent racist people from using it in a derogatory way. It's not derogatory if we're using it. It's not disparaging if we're using it to describe ourselves in order to reclaim it. And the USPTO examiner said no. And ultimately, it was appealed all the way up to the Supreme Court, which ultimately said that this was a First Amendment violation, right? That refusing to register the mark, the slants, on the grounds that it was disparaging was an improper limitation on the speech of a trademark registrant and not within the purview of what their trademark office is constitutionally permitted to do under the First Amendment. Unsurprisingly, there was soon afterward a similar controversy over scandalous marks. Essentially, what the court had held is that, or rather, what the trademark office had held was that it would not register marks that consisted of cuss words, essentially. So, anything that was deemed improper speech, arguably, the 7 dirty words under FCC v. Pacifica, right? Anything that was essentially improper kind of word to use, like shit, fuck, whatever, right? That was not going to be registrable. Okay, well, somebody named Brunetti had a clothing brand called FUCT, which he claimed was an acronym for Friends You Can't Trust. Here you can see examples of the clothing that he produced. Tried to register the brand name FUCT, or fucked, as you might pronounce it phonetically, and the USPTO refused to register. That was appealed all the way up to the Supreme Court as well. And ultimately, the court said, yes, this is also registrable, limiting people's speech on the ground that the word that they want to use is scandalous, is also not consistent with the First Amendment. And frankly, after Mattel v. Tam, and in light of previous opinions on the First Amendment, I don't think a lot of people were particularly surprised by the outcome of Lancu v. Brunetti. But it's very recent, and it's still hard to say what the sort of long-term repercussions of this decision are going to be. But it does go really deeply to, how we think about the meaning of registration. After all, from the Supreme Court's perspective, the court said, look, the USPTO shouldn't be able to make discretionary determinations about whether it registers or doesn't register a particular mark that somebody wants to use in commerce. It should be objective. It's not the USPTO's job to evaluate the appropriateness of the marks that people want to use. Of course, the response was, well, you don't have to register a mark at all, right? And a mark could still be protectable even if it's not registrable, right? The USPTO isn't stopping you from using the mark. It's just saying we're not going to register it. We're not going to have the government sign off on it. We're not going to have the government recognize it as acceptable, right? You can still use it. It could still even be protectable. It might be a little bit less well protected, but it's not like your actual right to use the word is being impacted. It's only the commercial effectiveness of the mark that's really being affected by the refusal to register. And it has already become clear that there is a certain number of people who are out there registering extremely offensive marks, especially extremely offensive racial epithets and so on. And at this point, the USPTO doesn't have any means of preventing them from doing so because it's precluded from doing so by the Supreme Court under the First Amendment. So query whether or not we think that was ultimately the best outcome from a sort of long-term social perspective, nevertheless consistent, broadly speaking, with the mine run of First Amendment jurisprudence.